The title of this PowerPoint is Judicial Activism versus Constructivism. Today's PowerPoint will discuss the differences between constructivism and judicial activism. And we'll go about talking about those differences by studying a few cases, one being Dred Scott versus Sanford, and the second one being the paramount case of Brown versus the Board of Education. We'll discuss these two different concepts and determine their pros and their cons. And then we'll talk about judicial discretion that judges have and when they should be used or if they should be used. And then we'll come to some conclusions on these different concepts. Let's start off with the definition of constructivism. Constructivism is a particular legal philosophy of the judicial interpretation that limits or restricts such interpretations only to the exact wording of the law. And that law is mainly the Constitution. What this is simply saying is that the judge has very little wiggle room outside of the interpretation of the actual document. So the wording on that document is law, and he can't differ away from that law. A good example of constructivism is Dred Scott versus Sanford, a Supreme Court case from the 1800s. Dred Scott was a slave, and his slave master, John Emerson, moved to a free portion of the Missouri Territory, and he passed away. And after he passed away, Mr. Scott, he contested that since he lived in a free portion of Missouri, he should be a free man. And he took his case all the way up to the Supreme Court. And that took about 10 years for that to occur. And he made his argument quite eloquently that he was a man and he deserved all the rights of all the citizens of the United States. Well, the Supreme Court ruled against him, stating that the Constitution, it had no provisions for slaves. So this meant that he was not a citizen of the United States. He was simply Mr. Emerson's property, and therefore he did not win his freedom. This is the perfect case for the philosophy of constructivism because it shows how, since the Constitution had no provisions for slavery, there was no other way to interpret the law. So, therefore, Mr. Scott did not gain his freedom, or was slavery or slaves looked at like citizens of the United States. They were simply property. The Supreme Court kept me from my freedom. Dred Scott. Judicial activism is the opposite of constructivism. It is a judicial philosophy that is sometimes referred to as legislating from the bench. It is an exercise of judicial review and generally refers to the willingness of a judge to strike down legislative or executive actions regarding constitutional issues. This simply means that it is more willing to contest precedents than constructivism. A good example of testing a precedent would be Brown versus the Board of Education. The doctrine of separate but equal has no place. Separate educational facilities are inherently unequal, Chief Justice Warren. To understand Brown versus education a little better, we have to understand sort of the conditions of that day. And those conditions consisted after the Civil War. Blacks were free, but treated as second class citizens. That means that they didn't share the same rights as their white counterparts. There was a system of Jim Crow laws that were created to separate blacks from whites in every aspect of life in the South and even some parts of the North. Things that you see from history, like blacks had to use certain bathrooms or water fountains, or they weren't allowed in certain places. Those were Jim Crow laws that would forbid them to do those type of things. One of the most important aspects of this separate but equal was that children couldn't go to the same schools. White kids had to go to one schools, and black kids had to go to a separate school. And the Constitution upheld this law from a case called Plessy and Ferguson that was in 1896. This just stated that schools could be separate, but they had to be equal. The reality of that situation is that they were not equal, and the blacks had poorer schools with a less than equal education to their white counterparts. That was the case until in the early 50s. Oliver Brown, he wanted his daughter Linda Brown to get the best education that was close to her home, but that school was all white. Mr. Brown's contention was that his daughter's rights were being violated by forcing her to walk past this school that was in walking distance all the way to a black school that gave her a less than equal education. So what occurred is he and several other families, they filed a federal lawsuit against the Board of Education of Topeka, Kansas. Thurgood Marshall, who was an attorney at that time, he became a future Supreme Court justice. He argued that Mrs. Brown's civil rights were being violated because the 14th Amendment guaranteed equal rights to all of its citizens. The Supreme Court viewed the case and they determined that Mr. Marshall's argument was correct, that her rights were being violated under the 14th Amendment. And the precedent was overturned. This is an instance when judicial activism changed a moral and unethical law. And it helped spark a civil rights movement that would lead to even more freedoms to blacks. By just these two cases, and we'll add a third case in, we can tell some of the pros and cons, the simplistic pros and cons between these two philosophies. Constructivism pros are that it operates on precedents. And a pretty good example of that is the Roe v. Wade, which is known as the abortion law. This precedent was put in place, and that precedent for many years protected the health rights of females. And that is a pro, that you have a law that's in place that it can be tracked and traced during court proceedings, and the judge can make his ruling based upon that precedent. That is definitely a pro. Um, a pro of judicial activism is that a judge has an opportunity to change an unethical or immoral law, like the separate but equal law in the case that we talked about with Brown versus the Board of Education. This is a pro because there was no morality in the way blacks were treated as second class citizens, and the court acknowledged that that should be overturned. That is a case where judicial activism worked, and that civil rights movement still continues today. There are cons to judicial activism, and one of those cons is that a judge can rule through their own personal opinion or their political opinion. And we've seen that recently with the overturn of the Roe v. Wade, which is a legal precedent that protected the individual rights of female health. And that has been overturned. And the popular belief is that it has been overturned because of political opinion. Constructivism cons are its lack of flexibility, as we talked about in the Dred Scott case, is that it was an immoral law that the Supreme Court had no way to overturn because the Constitution didn't speak on slaves as being citizens, they were property. So the court used the constructivism to not do anything about a law that they know was immoral. So there are pros and cons to both philosophies. In conclusion, we both understand that there are pros and cons to both philosophies. Constructivism bounds a judge to legal precedent which has been tested and studied. Constructivism cons uh, are that judges are unable to change immoral or unethical laws because of how the Constitution states or does not state things, as in the Dred Scott case. Judicial activism speaks to the morality of laws more freely from the bench, such as the case we studied, Brown versus the Board of Education. The cons of judicial activism can simply become a matter of political opinion or less about the precedent already set in place, as the case we spoke in of the Roe v. Wade, which has been overturned, which is viewed as a political overturning. The thing that we understand most is that both philosophies have to be handled with great care and responsibility.